Your Excellencies, distinguished delegates, ladies and gentlemen, welcome to this official side event at the 23rd session of the Assembly of States Parties to the Rome Statute of the International Criminal Court. Welcome to all of you here in the hall and also to the hundreds of participants who are joining us online via the live stream. This event will take place in English with translation into French, Spanish and Arabic here in the room via the headsets, but also in the Zoom online using the interpretation button where you can select your language. The event will be recorded in all 4 languages. For the benefit of the online audience today, allow me to introduce myself. My name is Nazat Shamim Khan, and I am a Deputy Prosecutor of the International Criminal Court. And I will be moderating this important side event, a 5th crime of ecocide, opening considerations. Discussion of a crime of ecocide under the Rome Statute has been growing rapidly in recent years, and side events at this Assembly have tracked its progress, from the initial examination of possibilities in 2019 to the convening of the independent expert panel in 2020, the emergence of a consensus definition from the panel in 2021, the relevance of this crime to the ever more concerning context of global climate and ecological crises in 2022, and the perspectives of some of the many and varied victims of ecocide at last year's Assembly in New York. In September this year, a formal proposal was made at the ICC's Working Group on Amendments to include an independent crime of ecocide into the Rome Statute, brought forward by the Pacific Ocean states of Vanuatu, Fiji, and Samoa. And so discussions have moved on to a more concrete phase. We are just at the start of the conversation, however, among state parties in the context of that working group. The Rome Statute is, of course, intended to address the most serious crimes of concern to the international community as a whole, those acts which most threaten the peace, security, and well-being of the world. In the context of the climate and ecological crisis, at least 3 state parties have made it clear that they firmly believe that the mass damage and destruction of vital ecosystems through human activity can be said to constitute precisely such a threat. And they have moved to open a broader conversation amongst states parties by putting forward this proposal. Already, support has been publicly declared in the context of a recent press conference by the Democratic Republic of Congo. It is worthy of note that the European Union this year adopted a revised environmental crime directive containing a qualified offence capable of addressing some conduct, and I quote, comparable to ecocide, as stated in the recitals of that directive, the first time that the word has been used in EU law. EU countries, a significant proportion of the states parties here assembled, will need to harmonise their own penal codes within the next 2 years to accommodate these provisions as a minimum. A number of states parties also have ecocide law provisions and proposals submitted in or progressing through their own domestic parliaments. We can observe, therefore, a gathering momentum around the recognition of ecocide as a serious crime, in the context of which the formal initiation of discussions in the Working Group on Amendments to the Rome Statute manifests as appropriate and timely. Today's event will examine some key opening considerations for the Working Group to consider: the overall rationale and timing for this proposal, the human rights implications of ecocide, the relationship of the proposal to parallel legal initiatives, the evidence for civil society support, some key definitional considerations, and the perspectives of youth. To begin with, I would like to thank our hosts, the Republic of Vanuatu, the Republic of Fiji, the independent state of Samoa, and the Democratic Republic of Congo for putting on this event in association with Stop Ecocide International, the Stop Ecocide Foundation, the UCLA Law Promise Institute Europe, and Climate Council. In 2019, Vanuatu, in this very hall, was the first country to urge states parties to consider the addition of ecocide into the Rome Statute. To open our discussion today, we have with us the Special Envoy for Climate Change and Environment for the Republic of Vanuatu, Mr. Ralph Regenvanu. Please, Mr. Regenvanu, the floor is yours at the podium. Thank you.
Your Excellencies, distinguished colleagues, members of the Court and guests, it is an honor to be here today to introduce this official side event to the Assembly of State Parties of the International Criminal Court, a fifth crime of ecocide opening considerations. We have a distinguished and diverse range of speakers on today's panel to address the key elements of the crime of ecocide. My nation, Vanuatu, remains committed to the Rome Statute system and its mandate in ensuring justice for the most serious crimes affecting the peace and security of humankind. Vanuatu ratified the Rome Statute in 2012, recognizing that strong and credible institutions are central to achieving international peace and security, and has remained a strong Pacific advocate of the Rome Statute system since then. Ecocide law is a topic of special importance to Vanuatu. We have a long history in promoting its adoption as a fifth international crime, being the first state to call upon this Assembly in its 18th session to seriously consider the addition of a crime of ecocide to the Rome Statute. It is fundamental to Vanuatu, as a vulnerable nation already facing the impacts of climate change, that the international community finds effective ways to deter, prevent, and create accountability for severe environmental destruction. Vanuatu supports a vision of justice that recognizes the mutually reinforcing relationship of human and environmental rights, and therefore considers the criminalization of ecocide as a crucial step in our collective fight against impunity. The international community has evolved since the Rome Statute was first elaborated, and as has the corpus of international law. There is a growing necessity, in light of critical threats to ecological and cultural heritages, to enhance the role of courts at national, regional, and international levels to apply environmental standards emerging from international policy considerations. In September of this year, Vanuatu, with co-sponsorship from the nations of Fiji and Samoa, took the formal step of proposing an independent international crime of ecocide. While Vanuatu recognizes that consideration of a new crime is not a matter to be taken lightly, we nevertheless believe it is a conversation in which it is critical for all state parties to engage. Severe environmental destruction, whether committed in war or in peacetime, carries widespread and long-term effects that cross borders and affect both present and future generations. Such destruction is moreover frequently central to the commission of existing Rome Statute crimes. Vanuatu maintains, therefore, that the relevance of ecocide as one of the gravest offences that threaten the peace, security, and well-being of the world deserves specific consideration in the statute. Discussions are now underway in the Working Group on Amendments, and we warmly welcome all state parties to contribute over the coming months and beyond. I thank you, Madam Chair.
Vinaka Vakalevu, thank you, Vanuatu, for opening this important conversation. I would now like to welcome remarks from His Excellency, Mr. Christian Dongala, Ambassador of the Democratic Republic of Congo in Brussels. The Minister of the Environment of the Democratic Republic of Congo, Madame Yves Bazeba, recently declared her country's support for the initiative of Vanuatu, Fiji, and Samoa concerning ecocide law. during a press conference in Colombia on the occasion of the UN COP16 on biodiversity. We are now pleased to welcome Ambassador Dongala here to the ASP. Excellency, the floor is yours.
Excellencies, ladies and gentlemen, representatives of the state parties, distinguished delegates. The Democratic Republic of the Congo is honored to take the floor today to express its strong support for the initiative put forward by the Republic of Vanuatu, Fiji and Samoa, to have ecocide recognized as a fifth international crime in the Rome Statute of the International Criminal Court. Our ecosystems, home to the world's second largest rainforest and the world's largest green lung in terms of carbon sequestration, provide us with vital goods and services such as the supply of food and medicines, climate regulation, air and water purification, pollination, and other services. These essential services are seriously threatened by destructive activities, which in many cases amount to veritable crimes against nature. The definition of ecocide proposed by the island states as unlawful or arbitrary acts committed with knowledge of the real likelihood that such acts will cause serious damage to the environment, which is widespread or long-lasting, would establish a crucial legal basis. By establishing personal criminal liability for decision makers, it would considerably strengthen accountability and have a truly dissuasive effect. This initiative marks a fundamental paradigm shift. Nature is not an inexhaustible reserve of resources to be exploited without restraint or wisdom. It is time to recognize that we can't extract resources indefinitely from a planet with limited resources, and that destroying nature is tantamount to compromising the very sustainability of life itself and the survival of humankind. COP16, which has just taken place in Colombia, has brought home to us all the urgency, necessity, and opportunity of establishing peace with nature. What's more, Vision 2050 aims to bring humanity into harmony with nature. Therefore, recognition of ecocide is a crucial step towards reversing the loss of biodiversity and towards putting nature back on the road to recovery. We will welcome this initiative, which we see as an effective solution, because criminal law, with its binding nature, is a powerful tool for responding to serious environmental damage in times of peace as in times of conflict. This legislation will have a transformative effect on project planning and policy making. It will encourage investors and companies to fully integrate environmental protection into their decision-making processes, placing nature conservation at the heart of their development strategies. This new legal framework will encourage the responsible and sustainable exploitation of resources in harmony with ecosystems and local communities. We recognize that the formal presentation of this important amendment is still recent, and we understand that many state parties want to enrich the discussions within the working groups on amendments in New York. We strongly encourage active and constructive engagement in the months ahead. In conclusion, the Democratic Republic of the Congo, as a solution country in the face of climate change and biodiversity loss, reaffirms its determination to support this crucial initiative, which represents an essential step in guiding the international community towards harmonious coexistence with our planet. Together, we can defend nature against its shameless predators for the good of present and future generations. Thank you for your attention.
Merci beaucoup. Merci beaucoup, Excellence. The Rome Statute at present focuses primarily on harms committed against human beings. However, we cannot escape the reality that the well-being of people and planet are inextricably linked. Indeed, states and commentators who support the move to address environmental harm through the Rome Statute point to this fundamental truth to explain why destruction of our shared environment should be considered to threaten the peace, security, and well-being of the world. We depend on and are part of nature, and ultimately the protection of human rights must entail addressing severe environmental harm. We are honored to present a message in this regard from the United Nations High Commissioner for Human Rights, His Excellency Mr. Volker Turk. His Excellency is not able to be here with us today due to commitments abroad, but he has supported the call to bring the crime of ecocide within the jurisdiction of the International Criminal Court, saying that ecocide legislation will strengthen accountability for environmental harms. Today, he has sent us a video message underscoring the intrinsic link between human rights violations and environmental harm. We welcome his intervention now on the screen.
Distinguished participants, colleagues, destruction of the environment by human beings is not new. Contamination of waterways or seabeds, destruction of forests or other ecosystems, eradication of biodiversity or specific species of flora or fauna, unsustainable, harmful extraction practices, flooding or conversely, diversion of water away from territory, use of weapons causing long-term or even irreversible damage to land, water and air. And all of these acts have been carried out in the past, particularly in conflict and war. But not only this. In peacetime, we have seen harm to the environment driven by business interests, by desire for profit, or by corruption, or even with the intent to harm a particular group or community. What has changed is not the acts themselves, although humanity's ability to do widespread harm to the environment has increased in scope and scale, along with our technological capacities. What has changed is our knowledge and understanding of the breadth and depth of harms that such acts cause and which can last generations into the future. To our planet itself, but also to the enjoyment of human rights, including the right to a clean, healthy and sustainable environment, clean air, safe water, adequate food, a safe and stable climate, a non-toxic environment, and healthy biodiversity. We know, too, that environmental harm can in turn be a catalyst for violence, social tensions, for poverty and displacement. And the greater the harm, the higher the risks of these cascading consequences for individuals, communities and societies, and even nations themselves. The understanding of a healthy environment as a universal public good makes clear the urgent need effectively to hold those responsible for its contamination and destruction, in wartime and peacetime alike, and using the full array of tools available at national and international levels. Recognition of the crime of ecocide under the Rome Statute, as has been proposed by Vanuatu, Fiji and Samoa, and supported by the Democratic Republic of the Congo, would represent a milestone in international criminal law and a pivotal advancement for guaranteeing the effective enjoyment of human rights both now and in the future. I therefore welcome the discussion that has commenced between states parties on this important proposal. It could help fill accountability gaps by ensuring that intentional infliction of severe, widespread or long-term environmental harm is recognized for its true gravity and does not go unpunished. By recognizing ecocide as an international crime, the international community would also promote the human rights to access justice and effective remedy, including for violations of the right to a clean, healthy and sustainable environment. Recognition of ecocide also would complement existing legal frameworks at both international and national levels. It is an important starting point that Article 8(2)(b)(4) of the Rome Statute itself already punishes, within the context of international armed conflict, the specific war crime of causing widespread, long-term and severe damage to the natural environment. And even outside of the context of armed conflict, Article 7 of the Rome Statute punishes, under certain circumstances, the severe deprivation of fundamental rights as the crime against humanity of persecution. In line with the crucially important language of Article 21(3) of the Rome Statute, its provisions should be interpreted and applied consistently with internationally recognized human rights, which also includes, of course, the human right to a clean, healthy and sustainable environment. And at national level, there have been important developments in a number of states to treat ecocide, formulated in various terms, with the legal seriousness such conduct deserves. Beyond criminal accountability, recognition of ecocide would be an important step forward in taking environmental harm seriously, in preventing it from happening in future, whether by states, businesses or individuals, and in ensuring justice and reparation for those who are affected, including through financial compensation, environmental remediation, rehabilitation and satisfaction. Environmental harm is no abstract threat. It is a pressing reality that endangers the well-being of both present and future generations. It is time to do more to stop it and to respond more urgently when it occurs. I welcome today's discussion in the margins of the Assembly of States Parties to continue to marshal momentum in this direction.
Thank you very much indeed, High Commissioner, for this timely and powerful address. We now come to our panelists. Let me turn to our first panelist, world-renowned barrister and author Philip Sands, KC, is Professor of Law and Director of the Centre on International Courts and Tribunals at University College London. A specialist in international law, he appears as counsel and advocate before many international courts and tribunals, including the International Court of Justice, the International Tribunal for the Law of the Sea, the European Court of Justice, the European Court of Human Rights, and indeed the International Criminal Court. Professor Sands serves on the panel of arbitrators at the International Centre for the Settlement of Investment Disputes and the Court of Arbitration for Sports. He is the author of numerous books on international law, including Lawless World in 2005 and Torture Team in 2008. His book, East-West Street, on the origins of genocide and crimes against humanity in 2016 has been awarded numerous prizes and has been translated into 24 languages. His latest books are The Rat Line, Love, Lies and Justice on the Trail of a Nazi Fugitive, and The Last Colony, A Tale of Exile, Justice and Britain's Colonial Legacy. Professor Sands co-chaired the independent expert panel for the legal definition of ecocide alongside Senegalese jurist Dior Fall-Snow. Professor Sands will be giving us a big picture perspective on the rationale for recognition of ecocide under the Rome Statute and why the recent amendment proposal is timely. Professor, you have the floor.
Thank you very much, Deputy Prosecutor, Madam Chair, and can I begin by thanking all of those who've organised this event today, put so much time and effort into convening, and in particular, the 4 countries that have decided to break the mould and formally propose an amendment. I really want to salute you, sir, in particular from Vanuatu, a country that I have a long relationship with, having served as an advisor to Vanuatu as far back as 1990, when something called climate change came onto our agenda before people really were thinking about it. I have come late, in a sense, to the subject of ecocide. It emerged as a subject in the late 1960s in the context of the war in Vietnam and the use of Agent Orange. The word was used in 1972 at the opening of the UN conference on the human environment at Stockholm. Olof Palme, you can see it on the video, you can find it on YouTube, actually refers to a day when ecocide will become part of our international legal order. I'm part of that generation that went to law school in the late 70s and early 80s when we were taught nothing about the environment. Literally, we never had a class on it, it wasn't part of our agenda, we just didn't think about it. And slowly it came into consciousness, in my case, on the 26th of April 1986 and in the days that followed, when there was an accident at the nuclear power plant in Chernobyl in the Ukraine. And we began to think, all of us, I think, who were around, on the way in which we are dependent on a shared environment. And that was a very catalytic moment because it transformed the international legal order by putting the environment really firmly onto the agenda. In 1996, the International Court of Justice for the first time recognized that as part of general international law, there was an obligation to protect the environment. And in 1998, of course, at Rome, in July, negotiations were completed to create the Statute of the International Criminal Court. I was there, I was on the delegation of Solomon Islands, and hence it's very touching for me, again, to be here in the context of a situation in which it's certain countries of the world that are leading in moving our international legal order forward. Amazingly, ecocide was addressed at Rome and in the negotiations of the Statute of the International Criminal Court, but it was considered to be too early. And I have to be very honest, I myself was skeptical. I was worried that it was too soon to begin to imagine using the world of international criminal law to achieve environmental protection. The 4 crimes in the Statute of Rome address the well-being of humans, and that, of course, is a matter of fundamental importance. But we've come to understand that we're not alone on this planet, and with that understanding and the significance of the natural environment, I've increasingly come to see, as part of my work on international environmental law, that there is something to be done on harnessing the criminal law to achieve the protection of the environment as an end in itself, something addressed in the best law review article I believe has ever been written, published back in 1972 by the remarkable Christopher Stone under the title, Should Trees Have Standing? Really the first time that a more ecocentric approach was articulated in classical legal scholarship. When Polly Higgins first approached me in the late 1990s and early 2000s on this issue, I confess I was skeptical and was supportive in the background of what she was doing. But what eventually caused me to change fundamentally my position and recognize that there is a need to amend the Statute of Rome to recognize the protection of the environment as an end in itself, not merely as an end to protect the well-being of the human species, was the work that I did in writing East-West Street. It took me back to that remarkable period of 1944 and 1945, and the moment when the concepts of crimes against humanity and genocide were first articulated by two academics, Hersch Lauterpacht and Raphael Lemkin, both of Polish origin. And they struggled, frankly, against vested interests and powerful forces to get their ideas up and running, but they did not give up. And in particular, I think the story of Raphael Lemkin is instructive for our times right now. In the face of tremendous opposition, he nevertheless ultimately succeeded, not with his own original definition of genocide, but with a form of words that came to be adopted in 1948 in the world's first modern human rights treaty. And those factors, that experience, watching what it meant when someone struggled with the consequences of mass murder and wanted to find a way to articulate it in the international legal order, I have to say, struck a powerful chord with me. And so when Jojo Mehta and her colleagues at Stop Ecocide asked me to co-chair with a distinguished Senegalese jurist, a working group of about a dozen individuals, to see whether we could come up with a definition, I thought, yes, that is something that I want to do. And I agreed to do it, and I did it with an open mind. It was a broad group. It was very much of concern to me that the group should operate by consensus and come up with a definition that was broadly acceptable to everybody, which meant that everybody had to make a compromise. There is here also, I think, a significant generational aspect. When the Guardian newspaper reported that I would co-chair this working group, it's the first time in my existence, and I think I do a few interesting things, that all three of my children in their 20s WhatsApped me separately and said, "Dad, well done, finally you're doing something useful." And that, in a sense, articulated for me your vital role. My generation has let you down. We have left you with a great steaming mess. And my generation has a responsibility now to recognize that. And many of you in the audience today are of my generation. We worked wonderfully as a group for about a year, and we came up with a consensual definition. And that definition, of course, is not perfect, and I'm not starry-eyed about the role that criminal law can have in dealing with these matters. We have Convention on Genocide, we have norms on crimes against humanity, and the horrors, as we know, have not stopped. But the fact that we have pieces of paper and conventions which articulate clear prohibitions under international law and ideas of individual criminal responsibility have shifted global consciousness. They have transformed the way we think about what human power is, what the power of a state is, and it basically articulates the view that no one is above the law under the international order. And that's, in essence, what the definition we adopted seeks to do. It's not ideological, it's not party political, it's not based in one particular part of the world. I think the composition of this panel articulates very clearly that this is something that is truly global and transgenerational. It's essentially about changing consciousness. It's essentially about thinking on the role of the law in different ways and recognizing that a system of rules that has as its sole objective the protection of the human is not enough. The High Commissioner for Human Rights has made an important statement today, and I warmly welcome his support, along with the Pope, along with the Secretary General of the UN, along with many political leaders, along with global youth. But let us be honest. Notwithstanding all of the difficulties currently faced by the International Criminal Court, its ability to deal with the environment is in effect close to non-existent. The current Rome Statute cannot deal with our real challenges today. It's all well and good to review the capacity of the existing Rome Statute to achieve environmental protection, environmental responsibilities, environmental liabilities. But let's call a spade a spade. The current statute is not up to that task. And it's better to address that head on and recognize for future generations that what is going to be needed is some sort of a change to recognize the protection of the natural world as an end in itself is a shared societal objective. And that's what this proposal is really about. And the one thing, in a sense, and those of you who know me well know that I take the long view on international law and on international criminal law. I don't expect governments to suddenly keel over tomorrow and say, oh yeah, we're going to have rules on ecocide, or oh yeah, we're going to adopt rules on ecocide. But it seems to me inevitable, and I would say even certain, I don't know the time frame, that there will be a change to the statute of the International Criminal Court, that we must amend it to impose the protection of the environment and individual criminal liability for massive breaches of the environment. And for that reason, I'm very proud to be associated with this panel. I thank Vanuatu, Democratic Republic of Congo, Fiji, and Samoa for their global leadership in what they are doing. It's going to happen, if not now, at some point in the future. Thank you very much for those who are putting this effort together. Thank you.
Thank you very much, Professor Sands. And of course, you remind us how much this conversation has developed from the time when no one spoke about the environment in the context of human rights. We now hear the right to a healthy environment being accepted by the Human Rights Council, and no one thought that in the context of international criminal law would we talk about the rights in relation to the environment. So here we are. I think it's an extraordinary place. It's very easy to be despondent about progress, but I think today is a day not to be despondent, but of celebration. So we now move on to consider the developments on ecocide in particular, yet global context of a range of legal initiatives being taken to address the climate crisis. As many of you will be aware, there is an important hearing going on here in The Hague in parallel to this assembly at the International Court of Justice. Vanuatu has been a leading voice in the context of the UN request for an advisory opinion on the legal responsibility of states with respect to climate change, a request that was passed by consensus in the UN General Assembly last year. Many states are now providing their testimony before the court over the course of this week and next to inform this advisory opinion. Our next speaker has been closely involved with this and other related initiatives. Professor Margaretha Wewarinki-Singh is an associate professor of sustainability law at the Faculty of Law of the University of Amsterdam. Professor Wewarinki-Singh's research, focus and teaching explore the role of law in transitioning to sustainable societies. Previously Assistant Professor of Public International Law at the Grotius Center for International Legal Studies at Leiden University and a Senior Lecturer in Environmental Law at the University of the South Pacific School of Law in Port Vila, Vanuatu, where she coordinated the Environmental Law Program and remains affiliated. She has published widely in the field of sustainability law, in particular on the major environmental law and governance challenges of the present and future of the Pacific, and has acted as a legal advisor to governments at international climate change negotiations. She has represented NGOs at the UN Human Rights Council and has advised the African Commission on Human and People's Rights and the Office of the UN High Commissioner for Human Rights on the nexus between climate change and human rights. Amongst many other positions, she is counsel at Blue Ocean Law, a boutique international law firm based in Guam, and serves on the Committee of Legal Experts of the Commission of Small Island States on Climate Change and International Law, which is mandated to promote and contribute to the definition, implementation, and progressive development of rules and principles of international law pertaining to climate change. Professor, you're here to tell us as to how an international crime of ecocide fits into the picture of these legal initiatives on climate. The floor is yours.
Thank you very much indeed, and Your Excellencies, distinguished delegates, colleagues, ladies and gentlemen. It's an honor to be here today to contribute to this crucial and indeed highly timely discussion. And I'd also like to extend my gratitude to the Republic of Vanuatu, the Republic of Fiji, the independent state of Samoa, and the Democratic Republic of Congo for hosting this important event. So we gather here today at what will be looked upon as a decisive moment in history, either way. First, the reality. We are witnessing an unprecedented crisis of environmental pollution, breakdown of the climate system, and a global extinction crisis never witnessed by humankind. And these crises are, of course, interconnected. They also demand a unified, robust legal response. And we're all working on that. That also marks this point in time. Just yesterday, we stood before the International Court of Justice to present arguments on behalf of Vanuatu and the Melanesian Spearhead Group, seeking an advisory opinion to clarify the obligations of states under international law concerning climate change and the legal consequences of breaches of these obligations. And this initiative emerged from a consensus resolution adopted by the UN General Assembly in March 2023. It underscores the urgent need for a departure from a framework where political convenience rather than international law governs action on climate change. So our submissions to the ICJ emphasized that the conduct leading to climate change is not just environmentally destructive, but unlawful under existing international law. And here we are talking about obligations under international human rights law, the law of the sea, environmental law, and general international law. We submitted evidence demonstrating that the breach of these obligations has already resulted in injury suffered by the most vulnerable nations and triggering obligations to make reparations. Now, parallel to this, the proposal to amend the Rome Statute to include ecocide as an international crime to addresses a critical gap in international criminal law. So while the ICJ advisory opinion seeks to clarify states' obligations and responsibilities, the Ecocide amendment focuses on individual criminal accountability for those who make decisions resulting in severe environmental destruction. And the relationship between these initiatives is synergistic. The ICJ advisory opinion has the potential to reaffirm and clarify obligations of states to prevent harm to the climate system, to cease wrongful conduct, to make reparations for damage caused. And this sets the stage for holding states accountable on the international plane. However, without mechanisms to hold individuals criminally responsible, those who orchestrate and benefit from environmental destruction, because that is the reality of the current system, they may continue to act with impunity. But the synergies go deeper. It can be argued, and indeed it has been argued in these proceedings before the International Court of Justice, that criminalizing ecocide is itself an obligation under international law. And this argument has emerged in these proceedings in different forms. So let me mention 3 of them. First, as an obligation under international human rights law, states must have positive obligations to take measures, including legislative measures, to protect against human rights violations. So those obligations exist for example, the right to life or the right to private and family life under treaties such as the ICCPR, the International Covenant on Civil and Political Rights, or the European Convention of Human Rights, or similar treaties. And specifically, they have also been argued to arise from the right to a healthy environment. And so it is the requirement that such measures be effective that may lead to the conclusion that at this point in time, there is a positive existing obligation to criminalize ecocide under domestic law and potentially also under international law. Then another way in which this argument emerges is in response to the second question that has been posed to the ICJ, which is about the legal consequences of breaches of these obligations. So in response to this first argument that states have these positive obligations to criminalize as a kind of special application of the obligation to regulate, sometimes it's said that, well, states have discretion to decide on the means by which they protect people, so they may choose to do so by criminalizing ecocide, but they can also choose other ways. The discretion of states. Now, the argument that Vanuatu, amongst others, has put forward is that, well, even if that is the case, this discretion is significantly reduced where a state breaches its obligations. And so we see such massive violations of human rights occurring as a result of, in this case, the harm that climate change has already caused, that the discretion is reduced and states must now take more stringent measures, and that then includes the criminalization of ecocide, because it may really be the only effective way at this point to ensure that A, the breaches are put to an end, so obligations of cessation, and B, also to offer reassurances of non-repetition. So that the argument is made in both ways by different parties. It's an obligation of cessation, effectively ceasing the breach, and it is an assurance of non-repetition. And now today, this morning, we heard another argument being made which leads to the same conclusion, but perhaps even more strongly, where building on the argument put forward by Burkina Faso that the obligation to not cause damage to the climate system and other parts of the environment has now a jus cogens status in international law. Building on that argument, Cameroon argued that where that obligation is breached, then special consequences, of course, arise, including the obligation not to recognize the situation resulting from the breach as lawful and to cooperate to end the breach. And so it is in connection with this argument that the proposal that has been put forward by Fiji, Samoa and Vanuatu becomes particularly relevant, because here we see essentially that a very plausible argument not only can be made but has been made already, that it is an obligation to actually cooperate to achieve this amendment. So of course the rationale is very clear. The inclusion of ecocide as a distinct crime in a Rome statute would create a very important legal deterrent against environmental harm, signaling that the international community will not tolerate actions that threaten the very foundations of life on Earth, and holding individuals, whether they are corporate executives, government officials, or others in position of great power, accountable for decisions that result in widespread, long-term or severe damage to the environment. And the urgency of these initiatives really cannot be overstated, because political negotiations have really proven to be woefully insufficient to address the scale of these interconnected environmental crises. The recent failure of COP29 in Baku to reach any meaningful agreement on cutting emissions is again a stark reminder of the limitations of current approaches. So legal accountability could really offer a path forward where politics has stalled. I would like to encourage all state parties to engage constructively and indeed with collective wisdom in the discussions within the working group on amendments. The inclusion of Ecocide in the Rome Statute represents an opportunity for the international community to demonstrate a shared commitment to safeguarding our planet for present and future generations, and honoring our shared responsibility to uphold the rights and dignity of all peoples and our more than human kin.
Thank you so much, Professor. And all the people in this room will know that ultimately one of the most difficult conversations about the applicability of the Rome Statute and domestic laws is the extent of space which is given to a sovereign country to demonstrate to the ICC that they have the laws and they have the willingness to prosecute. And so what will be interesting if this proposal goes forward and it is eventually adopted as an offence under the Rome Statute is the extent to which then domestic jurisdictions will be forced as member state to step up to have their own domestic laws for ecocide, and therefore to reduce the gap in terms of accountability between domestic laws and international laws. So we look forward with interest to the advisory opinion of the ICJ, also to see the extent to which these concerns are also incorporated. Let me now turn to civil society. We know that civil society advocacy has been central to driving change worldwide. And it is certainly the case that these discussions about ecocide have been discussed in the academic world and in the media to a much greater extent in recent years. And certainly there has been an increase in academic articles on the subject by 40 in the last 5 years, and increasingly also in the media. Our next speaker is Sandrine Dixon de Clèves, co-president of the Club of Rome, one of the world's most eminent collectives of business leaders, scientists, and intellectuals focused on the world's most pressing problems. Ms. Dixon de Clèves divides her time between leading the Club of Rome, advising, lecturing, and facilitating difficult conversations in many contexts in the public, private, and civil society sectors. She is the executive chair of the Club of Rome initiative, Earth for All, but she also sits on a number of advisory boards and in non-executive positions relevant to the protection of the environment. And she is senior associate and faculty member of the Cambridge Institute for Sustainability Leadership and an ambassador for the Energy Transition Commission and the Wellbeing Alliance, We All, and a fellow of the World Academy of Science and Art. In 2020, she led the Club of Rome to join forces with the Potsdam Institute for Climate Impact Research to create a planetary emergency plan. She is also a TED global speaker and author. She has been recognized by Reuters as one of the 25 global female trailblazers in 2023 and by GreenBiz as one of the 30 most influential women across the globe driving change in the low-carbon economy and promoting green business. She joins us today from the United States. Ms. Dixon de Clèves, we are very keen to hear from you about what you have learned through the survey carried out this year by Earth for All and the Global Commons Alliance, and in particular in regard to ecocide law, but also in the context of the role and responsibility that the public ascribes to government in the current situation of global crisis. The floor is yours.
Madam Chair, thank you so much, as well as Your Excellencies, members of this court and distinguished guests. Thank you for inviting me and bringing forward the case of civil society and the need to ensure that ecocide becomes recognized as the fifth international crime. The link between humanity's survival and a healthy operating space for humanity on this planet we call home is fundamental. Climate change and biodiversity loss are the greatest existential threat to humanity. And we have known since 1972, the distinguished members of the Club of Rome, but also scientists and economists across the globe, that this is a growing deep crisis of both social and environmental tipping points. In the limits to growth, we have seen that with population growth and also the focus on extraction and productivity, that this is actually the greatest threat to human well-being on this planet. What we are seeing already across the globe is that global well-being is declining. This is a human threat, not only a planetary threat. With GDP growth and population growth and climate change and biodiversity loss, we're seeing a large chasm of well-being actually reducing and high social tension increasing. But in addition, the newest results from economists across the globe and from scientists is that the cost of inaction is greater than the cost of action. That at 1.5 degrees, we will lose 3% of GDP growth. And at 3 degrees, we will lose upwards of 10%. So ladies and gentlemen, this is not only a crisis for our dear planet. Ecocide, as I indicated, is a human crisis. And what do people across the globe think about ecocide? This is incredibly important. We interviewed G20 citizens representing about 22 countries and 22,000 participants overall from the age of 18 to 55 to 75. And we saw in our survey that 72% agree that ecocide should be a criminal offense. We also were shown by the survey results that 88% are worried about the state of nature today, and 87% are worried about how we'll leave it for future generations. Now, what is important is that people across the globe, global citizens, are increasingly aware that we are reaching both social and environmental tipping points. 69% of people interviewed agreed that the Earth is close to climate and nature tipping points. Most people know that we need action now. 71% of the survey results showed that people believe that the world needs to take immediate action within the next decade to reduce carbon emissions. And of course, 52% of those actually most exposed to climate and environmental risks are calling for change right away because they are personally affected by both climate change and biodiversity loss. These results, ladies and gentlemen, show that actually, although we are often told by governments and by political parties who have politicized climate change, nature, in order to create greater fear and inaction, that actually the link between people, politics, and planet is very much a link which demonstrates that actually even those governments that are moving towards the radical right, that the politics and the center right are demonstrating that people believe that there is a need for action. What is important here is how we can bring more citizens on the journey. Those citizens that we have interviewed have very much indicated that it is time for action now, that it is time to have an ecocide law in place, but we need to understand how to better communicate and put in place the democratic processes in order to enable that to happen. With more citizen assemblies, with more town halls, the backing of our polling enables us to move forward and bring more people on this journey of change. Ladies and gentlemen, let me end by indicating just how fundamental it is to continue to push for an ecocide law that is actually in place across the globe. The fact that we are having this discussion today is fundamental, and it is happening at a time when we know how difficult it is to continue our pursuit for climate justice, for environmental justice, and for humanitarian justice so that we can survive on this planet we call home. Our publication, Earth for All, has stipulated exactly how we can continue to live within a safe operating space and guarantee that people can thrive, not only survive. We must ensure that an ecocide law becomes recognized as a fifth international crime and bring both the legal jurisdiction in line with ensuring that we communicate with people, that we bring citizens on board of this very important journey and protect today the most vulnerable, but tomorrow those living across the globe, both in the global south and in the global north. Thank you very much.
We have Professor Darrell Robinson, Professor of Law at Queen's University in Canada. He is a former Canadian diplomat and legal advisor. He helped to negotiate the statute of the International Criminal Court, including the definitions of crimes. He was involved in the negotiation of the ICC elements of crimes. He helped to draft the Canadian legislation on international crimes, and he has assisted other countries with implementing legislation. He is a recognized expert on concepts and principles of criminal law and international criminal law, and he is, in fact, a former employee of the Office of the Prosecutor of the International Criminal Court. Professor Robinson, the floor is yours.
Thank you. I'm going to outline for you some of the main issues in the definition of ecocide. This matters both for the discussions here, looking at the ICC's statute amendment proposed by Vanuatu and others. It also matters for the many countries that are right now looking at passing national legislation on this. There's three big ingredients in making an ecocide definition. Number one is the impact threshold. What's the scale that warrants this label of ecocide? Number two is the mental element. What is the fault going to be? And then the third one, I'll call it a wrongfulness requirement, which is we need something that aligns it with environmental principles in some way. So starting with the first ingredient, the impact threshold. Most proposals, including the proposal developed by the panel and submitted by Vanuatu, use some version of the formula widespread, long-term, and severe environmental harm. There's good legal pedigree for those terms. They appear in Additional Protocol 1 of the Geneva Conventions. They're in a convention on environmental modification. They're even in the ICC statute in a war crimes provision. Most sources use those terms conjunctively, so you need all three, but some of them use them disjunctively. The panel definition takes a middle path, a hybrid, where it has to always be severe, the damage, and then either widespread or long-term. That makes sense because it makes sense to require severe because ecocide, the idea of ecocide is it's dealing with severe harm, so it makes sense to have it as always required. So the second big ingredient is the mental element. One narrow option, it would be to use intent, that someone has to intend to harm the environment. But you know, it's quite rare that anyone would act with the purpose of harming the environment. Intent also includes when there's a side effect that you know is substantially certain. But even that is problematic because in environmental science, these kinds of impacts are often not predictable with certainty. So the definition by the panel and put forward by Vanuatu takes a different approach of knowing that it's substantially likely. That's a familiar concept from national systems. We all use different terms to describe it. Some systems would call that recklessness or dolus eventualis. It's also used, you see the idea of knowledge of likelihood in tribunal jurisprudence. Now, at the ICC, Article 30 of the statute says that intent is the default mental element where no mental element is provided. But the article specifically says unless otherwise provided. So the article lets you stipulate a different mental element. And the states parties have done that already in the statute and in the elements of crimes. We've done it with child soldiers, for example. This idea, knowledge of likeliness or even knowledge of risks, is something that's already in ICC documents. For example, in the elements of crimes, there's a war crime of misusing flags of truce or distinctive emblems, and it talks about knowledge of risks. So this idea of knowledge of likelihoods, it's something that fits with the international criminal law system, and it complies with the culpability principle. So the third ingredient is what I'm calling a wrongfulness requirement. I think that's the hardest part. How do we align this crime with environmental principles? And you might ask, why do we even need to do that? But there's reasons of legitimacy and legality as to why an international crime of ecocide should be in some kind of conversation with established environmental principles. And those principles recognize that we actually have to have some ecological footprint to survive, to get your food and your energy and your house and your clothing. You have to have some footprint. But what the principles try to do is promote better environmental stewardship. So we have to ask ourselves questions like, is this the least harmful option? Are you doing everything you can to mitigate and prevent harm? Are you achieving equity between present and future generations? Questions like that. So the proposed crime of ecocide, it focuses on irresponsible conduct that breaches these existing principles. And in doing so, the hope is to strengthen compliance with them. The way the proposal does it, the way the proposal captures this idea of irresponsibility, it has this formula: unlawful or wanton acts. So unlawful means conduct that's unlawful in international environmental law. But it also includes conduct that's unlawful in domestic law. That's important because a lot of the worst transgressions today are actually illegal in domestic law. The domestic law is just getting ignored. So a crime of ecocide with that already covers a lot of the destruction we're seeing today. The definition could stop there with just unlawful, but there was a concern: what if national law doesn't regulate something? Or what if completely unreasonable permits have been issued? So the definition includes another option, which is or wanton acts. Wanton is an old word, but it captures this idea of reckless irresponsibility. The proposal defines wanton as reckless disregard for harms that are clearly excessive in relation to the anticipated benefits. I think the idea behind that is it's looking for conduct that would fail any rational environmental impact assessment. So it's an opportunity to directly apply the environmental principles. There are strengths and weaknesses for any possible formulation for this. States have already accepted a balancing formula like that in the context of war crimes. It's possible that discussions here might wind up refining some of the definition to provide criminal law clarity. But the essence is we need some test that captures egregious conduct that's in disregard of our shared duties of environmental stewardship. There's a lot of other nuances in the definition. I've just given you a short overview. There's an article easily found online if you want that delves into this all a little bit more. But I hope my little survey here has given you a sense of the biggest issues in the definition. Thank you.
Thank you so much. And of course, a question that we all have in the criminal law world is how you reconcile concepts of environmental harm and degradation with what we consider to be traditional concepts of criminal responsibility. And the expert panel did it so well. But let's see what the states make of the balance as you outline it. Let me now move to a perspective of youth. So Professor Sand said earlier, we're so sorry for what we have done to the environment. We aging and aged people in a position of trustee have not done so well with this relationship of trusteeship. And so important in any conversation about movement on the environment is to hear the voices of young people. And we are very lucky today to have with us Debbie Buaki, who is a tree planter, founding a tree planting and growing project that now covers 6 of the 7 continents, going into thousands of trees and a number of notable awards. She is current global co-lead at Youth for Ecocide Law and lead at Youth for Ecocide Law of Africa, working with Stop Ecocide International to have massive environmental damage, ecocide, including as a 5th crime under the Rome Statute. Her special focus is children, youth, and Indigenous peoples' protection through this legislation. She is the author and host of a climate-centered podcast, Flight Over Nature's View. Her background is in criminal justice and criminology and international law. Ms. Buaki, the voice of youth, please, in the context of our discussion. Over to you.
Thank you to all that have spoken before me so well. Excellencies, distinguished guests, colleagues, ladies, gentlemen, and the entirety of warrior souls from across the world. It's my true honor to have a chance to put voice to the inhibition of the many that couldn't be here today. With silence like a wilderness, I invite you to spend this next 10 seconds with me to listen and attempt to see the frail heartbeat of our planet. To the 3 species that go extinct in every passing hour, to the over 100 whales this year ordered to be legally murdered in Iceland, the 200,000 acres of rainforest that will, by end of today, be gone, rendering thousands desolate, the 97% of Earth's ecosystem that is no longer ecologically intact, meaning that only the remaining 3% of land is what has been left as undisturbed habitats and healthy for original species to grow and inhabit. The 99% of coral reefs projected to die off if global warming reaches 2 degrees. All this and more inherent carbon sinks that continue to diminish. Surely shall I go on? Shall I continue to hold up the mirror for us? We cannot separate ourselves or talk about nature or Earth without adding ourselves to the sentence. There are 8.7 million species on Earth: birds, insects, plants, bacteria, and also on this list are human beings. Earth, as do all these species in all their different ecosystems, deserve life as much as we do. How could we survive without each other? Where will our water, our air, our essence, our being come from? Whatever fabric of life that makes them is the same fabric that we are cut to from. Gearing up to the 2030 benchmark, the science has been clear all along. We need to change our actions, or Earth will not sufficiently be able to support the life of us and the billions of other species existing in it. However, the climate and ecological crisis, if not emergency, is seemingly not alarming enough, especially to its huge contributors. Accountability has become a concept that has been thrown out of the window and the window of a burning house called Earth. Young people across the world continue to be clear that this cannot continue. It has to stop. It has to stop. We are, and soon will be, the majority of the world population, and are the next, if not the current generation of change. If I may give you an example, in the previous years, what if we fought so hard to defend the human right to life if there was no existence of a law that says, do not kill? How then would we defend that right if murdering was permissible? When it comes to the environment and its ecosystems, how can we try so hard myself included, who's planted thousands of trees globally, and many other youth out there striving to clean oceans, cleanse airs, and so on, how then can we try so hard to fix the planet if the opposite, destroying it, exterminating it, is not wrong? We need a guardrail on how far we can go with killing our only known home, as the word ecocides is derived in Greek and Latin, meaning is derived in Greek and Latin. Allow me to zoom in on my beloved Africa. The reality of this needed guardrail is a literal matter of life and death. The second lung of the earth, second to the Amazon rainforest, is found in the delicate ecosystem of Congo. Oh, and best believe we cannot talk about anything in Africa without mentioning Congo. For example, the just transition that we highly have spoken about currently has Congo as its middle name. The world's largest single mass deposit of minerals required to support the transition, the EVs we so highly praise, are found in Congo. What then does it mean for the rainforest there? What does it mean for the ecosystems there, the communities there, the indigenous peoples there? Is it mass extermination, mass extinction, ecocide? Crude oil and rare minerals like vibranium, now found in East Africa. What does it mean for them? What does it mean for the entire African mineral corridor? Of course, development must happen. Economies must be built, don't get me wrong, but how will it be done? And what is the price for it? Is killing everyone's only known home too high or too low of a price? Let's shift gears before we begin to have the famous argument of people versus profit and economy versus environment. On this other side, allow me to show you the rare beauty found on African soil, its youth. 70% of the population in Africa is made up of youth, the strongest, largest, most intelligent workforce of the continent. What then does it mean for success if we actually do include the majority of the population on all decision-making tables? What will it mean moving forward? What will it mean in terms of sustainability and continuity of decisions such as to vote in favor of the Ecocide law? What will it mean to pass the baton? We have the numbers, and it will be prudent to have the majority of the population in support of the decisions pivotal to all. We cannot be excluded. In conclusion, in society, the law represents what we value, what we want to protect, preserve, and even regenerate. It's like a mirror, a reflection of our values, our morals as human beings, and our deep consciousness. I implore you to stand on the right side of history, the just side of history, the justice side of history, to support the amendment of the Ecocide law. 50, 60, 80 years to this date, to this moment, I hope we'll be proud that we did. Although fickle, although rapidly diminishing, as long as there's life, there's hope. But this life needs to be protected to maintain this hope. This is our chance to write down our legacy on this planet. Let's do it right. Let's do it right. Thank you.
Thank you. And I think on that note, we couldn't ask for a better way to conclude this panel discussion. The Rome Statute was already an enlightened piece of work when it was negotiated, because it reflected not only the law as it was in many domestic jurisdictions, but it also reflected the way humanity thought that the law should be. And in many ways, it has already shown an ability to embrace new ideas. It has shown an ability to really look, for instance, at gender-based crimes, to see whether the Rome Statute is able to encompass the way that, sadly, humanity behaves. But it also, this particular conversation is also not just about how enlightened the Rome Statute is, but how relevant the International Criminal Court is to the contemporary problems that face the world. And so this conversation is one that is very important for humanity now. And I'm very proud to have moderated this panel, and I thank all our panelists for their stimulating and wide-ranging interventions. And again, I thank our hosts, the Republic of Vanuatu, the Republic of Fiji, the independent state of Samoa, the Democratic Republic of Congo, and supporting organizations, Stop Ecocide International, Stop Ecocide Foundation, UCLA Law Promise Institute Europe, and Climate Council, as well as the teams which have facilitated the translations and the live streams. And I thank you, Special Envoy of Vanuatu, and thank you also, Ambassador of the Democratic Republic of Congo, for their interventions. In closing, I would like to emphasize the importance of this conversation in the context of the Rome Statute and of international criminal law, which face a challenge to their own relevance, as I have said, if they do not accept the need for adaptation and flexibility in relation to the reality of what is happening in our planet. I've noticed in the last 2 days the unprecedented number of small island states which asked for accreditation to attend this ASP. And I cannot but conclude that the interest of the small island states is because of this conversation. I think they're coming to hear what we have to say about the environment. So again, a well-timed, extremely important conversation. And I, as a native of Fiji, am aware of the importance of this conversation. It is, in fact, a conversation that is about the existence of a small island state in the Pacific. So there is growing global awareness about the protection of the environment, and in the context of the Rome Statute, one that I believe will guide our deliberations in the next months. This conversation is now formally part of the working group's deliberations, and I know we will be following the developments closely in the next weeks. I would like to acknowledge that states parties may well have specific queries related to the Ecocide amendment proposal that has been put forward, and we don't have the time to have that discussion now, but I am pleased to advise that a more informal event, a legal clinic, on the topic of the definition of ecocide and related issues will be taking place here in the World Forum tomorrow from 3 to 6 p.m. in room Everest 2 with experts, including Professor Robinson, present to address your queries. State representatives and legal advisors are warmly welcome to attend. Thank you to all, to the audience, both in this room and online. It's been an honor and pleasure to have you with us, and an honor and pleasure for me to moderate this panel. Thank you, and thank you to the panelists again.